Welcome to Solving Citizen Legal Encounters. All right, today we have a pro se defendant who's being. Welcome to Solving Citizen Legal Encounters. All right, today we have a pro se defendant who's being sued for not paying his loan back. But this pro se defendant wants to do a countersuit, and you wouldn't believe what he's countersuing for. Let's go and check out the video and see what he's countersuing for, and make your comments. Let's go.
And then Crown Asset Management versus Michael Whitney. Mr. Whitney, can I see you, please? Thank you for your patience, Mr. Pippin.
Yes, ma'am. Thank you for your patience, Judge. It's one of those days.
Yeah, I just try and take it slow and explain everything as I go. I don't like for people to leave here at least not knowing why I made the decision I made.
Yes, ma'am. I understand, and I think the explanations are very helpful. So I get it, especially for the pro se people.
Mr. Whitney, are you having technical trouble?
No, ma'am, I'm here.
Okay. Can you show me your image?
Yeah.
There you are. All right. So Mr. Whitney, Mr. Pippin, this is Crown Asset Management. Mr. Pippin is here on behalf of the plaintiff versus Michael Whitney, who is pro se. It's a counterclaim. It's a contract breach of contract claim and a counterclaim. So, Mr. Pippin, if you'll give the court the information regarding the claim, and then I'll hear from Mr. Whitney on behalf of the counterclaim.
Yes, thank you, Your Honor. Again, Joe Pippin here for plaintiff. Judge, I know it's late. I'll be very brief. This was
That's okay.
a loan.
Take the time that you need. This is what I do. So
Yes, ma'am. Okay, thank you, Your Honor. But it is very succinct. This is a personal loan that the defendant requested. It looks like February 7th of 2022. The creditor was Cross River Bank. It was a loan for $5,000 with an 8.97% APR, finance charges of $725.80. So the total that was to be received per the loan terms was $5,725.80, payments of $159.05 starting on March 10th of 2022. I'm looking to see the date of the last payment. I had it earlier. It was shortly thereafter, Your Honor. It was in 2022. I'm not trying to hold up the court. At some point in 2022, the payment ceased. Subsequently, the account was closed.
That account didn't make it a whole year.
It was transferred, Your Honor, and I believe attached with the plaintiff's business record affidavit, that certificate of sale of accounts was also filed. And in case that's, defendants, I anticipate will argue that he's had no relationship with Crown Asset Management. The account was acquired by them from Cross River Bank, the original loan that he had. And I believe that's, Judge, that's about it. As if I can may briefly, though, address the counterclaim that is going to be brought.
First, let me understand. So the entire amount that you're asking for on principal is $5,721.80.
Just double checking. I'm double checking, Your Honor. Yes, that's correct, Your Honor. Actually, just $5,000 in principal and court costs.
Okay, so they're only asking for the initial loan principal and court costs in the amount of.
I'm showing 214. No, see, I'm sorry, Your Honor. 266.
$266.
And that's it.
All right, Mr. Whitney, go ahead and tell me about your counterclaim, sir.
Oh, Your Honor, my counterclaim comes from. Let me get my notes together. Sorry about that. So basically, I believe Crown Asset Management, well, is this right? Well, it was Reagan because that's who I was communicating with. Feel like they just conspired and unlawful, asserted debt in a scheme to defraud my personal property.
Okay, so sir, just tell me what you're asking for and why. You don't have to read from it.
As far as
Because it'll be a lot
far-
easier for me to understand what you're saying if you just use plain language.
okay, so you said as far as what I'm trying to countersue for, like the amount?
Yeah, tell me the amount you're suing for and why.
Yeah. The principal, I was doing 350,000.
He owes them 5,000, but he wants 350,000. I don't know how he even added that up.
So you wanted $350,000 from them.
Yes.
Okay, and why?
My reason is so my reason would be is because I just feel like what I've noticed, the CAM LLC is like they're violating public policy and personal rights as far as attacking people who they feel like probably ignorant to the law, who can't represent themselves. And they do this all the time after I've done my research. It seems like this is what they do. It's like how they make their money. You know, they go purchase debt from people probably from low income areas, what I've seen, and they want to come for them. And I feel like remedy must be demanded for that.
Let's break this down. He borrowed $5,000, which means he made contact with them. He didn't pay them. Now they want their money back, but they're coming after people who are less fortunate.
Okay, so if I told you it was legal for individuals and companies that have debt to sell it to other companies that wish to purchase it, and those companies can thus pursue the debt under either a purchase agreement or an assignment, then there would be no basis for your $350,000 claim. Are you denying that you owe this debt?
I feel I extended my
No,
credit
not
to
what
them.
you feel. Are you denying that you owe the debt from
Yes,
this
yeah, I'm
loan?
denying that I owe
Okay,
them
so
debt.
you're denying that you took out this loan and failed to pay.
Yes.
Huh?
Okay, Mr. Pippin, do you have anything that shows Mr. Whitney's connection to this loan?
I do, Your Honor. Believe attached with the summons and complaint, in the business records, we have the contract he signed. Looking here, bear with me 1 second, Judge.
No problem.
Page 7. Let's see. I know the court has received a lot of documents on this one. Let's see. Okay, the contract. Here we go. Signature page. Now it's DocuSigned, but as you know, I'm sure Mr. Whitney's been listening to other cases. A valid an electronic signature is considered valid, and this document was DocuSigned electronically. It looks like here February 4th of 2022, requesting the loan. The funds were transferred to Mr. Whitney. Therefore, he did receive the benefit of the loan, and then failed to pay on it.
Were they
So-
transferred to an account or were they transferred by a check?
It's a great question, Your Honor. I'm looking to see. I'm not certain, Your Honor. I'm not trying to hold up the court.
No, that's okay.
Okay, one thing that I had to do already was cut out some of the dead space because he is looking for things. And so far, I'm sure you're already seeing this, but he's not prepared, in my opinion, for this case because every time she asks him a question, he has to go back and look. And it seemed like before you come to court, you want to look at the case and make all your case notes so when the questions are answered that you know the judge is going to ask you, you're ready for them.
Let's see. I'm sorry, there were people passing by, Your Honor. Let me mute first. I'm sorry, Judge. I'm pulling it up here. I'm seeing that
Are you able to
No.
share screen?
yes, Your Honor. I'm glad to. Let's see here. Let's see. Okay. All right. I believe, Your Honor. Can you see that? This is Can the court see this okay?
Yes, sir.
All right, that's the signature page there. 2/4 of 2022, DocuSigned by Mr. Whitney. It also does say, I agree to pay Cross River Bank all sums disbursed under the terms of this loan agreement. I acknowledge I have received and read the disclosure statement. And I'm looking to see how the funds were transferred. That was February 4th. This right here, this shows the final demand. So multiple attempts were made to work with Mr. Whitney and try to get this account caught up.
Were the notices sent by mail to the address on the screen?
Yes, Your Honor.
Okay, so this wasn't one where they were just emailed.
That's correct. The North Hill Court address. Yes, ma'am.
All right, and when Mr. Whitney was served, was he served at that address?
Let me look through and see, Your Honor. Yes, that is the address listed on the summons and complaint.
Okay. All right, and did he respond to the summons and complaint?
My understanding is, I believe the response was the let's see, the demand for full disclosure. Okay, yes, there was a response. That's what this is, Your Honor. And it appeared to plaintiff that there were about these, we treated these as interrogatories, Your Honor. This is the defendant's response. There's
Okay.
50 questions, all of which were responded to. And then he alleges all these damages, and I believe that's how he gets to the 350,000 number. Again, Judge, these are all completely unliquidated, and the plaintiff would argue these are baseless. Defamation, intimidation, conspiracy, racketeering. There's a lot of crimes alleged, and illegal activity, with none of which has taken place.
Okay. Did he reference an address on this filing?
I'm looking to see. Yes, ma'am. Right here, this is what he prepared, this 204.
Is that the same address on the contract documents that you have?
I will scroll back down and look, Your Honor.
The screen is covered because his address keeps appearing as he scrolls back and forth.
Yes, ma'am.
All right. Mr. Whitney? Do you have any questions about this document?
Yes. So, let's see. So that's I believe it's the Cross River Bank document. Can't really see it.
Well, it's the Cross River Bank document and also your response to the lawsuit.
Yeah, my counterclaim. I have questions about let me see, I'm sorry.
Was
So
that hold on. Was this a
return receipt?
Yeah.
Yeah, I'm not sure. I can't read it.
Well, it says that it was addressed to Michael Whitney Jr. 124, and somebody signed for it.
Yes, so I put in demand for the full disclosure before I was served. So we started communicating before I was actually properly served. So I would like to look at the dates. I was served in February.
Okay, so let's go back a step. So the $350,000 counterclaim, the court has reviewed it. I'm just making Mr. Pippin put it on the record, but sir, there's nothing in there that you can prevail on. Most of those are like criminal matters. You just went through some internet search and found a bunch of stuff, but none of it is really relevant to what I have to deal with today.
So, could you repeat that how lawful it is for them to debt collection agency to go buy the debt and without my consent?
It's allowed, sir. It's just like when somebody buys a house, almost before you close on the house, they're going to sell your mortgage to some other servicer. So if you've ever bought a home, once you close, you may close with one mortgage company or bank, but by the time you get your first payment out, they have sold that debt to someone else as a servicer of the debt. And they've taken the money and what money they could get from this bundle of debt, and they move on and they go somewhere else. So is legal. Not only is it legal, it is so commonly done, it's not even a thing that people worry about. The only thing I have to worry about is that there's something that shows the assignment or the sale between the company that issued the loan and the company that bought or was assigned to collect the loan. Mr. Pippin's clients have provided that information in the court's record. If they had not, we would not be having this hearing, or I would have brought it up at the top of the hearing, because it's part of what we look for. So yes, sir, it is legal, fully legal, for any company that has debt and holds a loan that is owed by someone else to sell that loan to someone else or some other business to collect. Happens all the time.
And if I may, Your Honor, that's exactly what happened with my own mortgage. It was a year after I bought my condo, it was transferred. And that didn't mean I didn't have to pay the mortgage. I just had to pay mortgage company B
It's
instead of
somebody
mortgage
else.
company A.
Yeah.
Yes,
So
ma'am.
it happens.
So, okay, I have a question. If I could ask a question.
Sure, Mr. Whitney.
So, okay, so from my research, I have found out that basically, so when I extend my credit, does not make me the creditor.
I don't know what to say to that comment.
No.
So, like,
You're the debtor. You're the
so I'm
debtor.
the debtor.
Yeah.
So, okay, so pursuant to 12 CFR 215.3, like that is interpret that when a person extends their credit, they're the creditor.
Sir,
Or
to extend credit means that, so it's like a credit card. If you have a credit card and you take your credit card and you buy something at a business, the company, American Express or Visa, is the creditor because they are extending you credit to purchase. So they're saying he's going to purchase with our card. We're going to handle getting the payment on the back end. He's going to pay us. But business, go ahead and give him what he's asking for, because he holds this credit, this card that says eventually we're going to pay you and he's going to pay us. So they're the creditors because they have the credit. They're extending you the credit in order to purchase. And then you are supposed to pay them back for the credit they extended you. You're the debtor, they're the creditor. Mr. Whitney,
okay,
you have gone all down the wrong road, sir. Did you go to anybody who could explain this to you instead of just doing your own research? You know what professionals hate to hear, what doctors hate to hear, what lawyers hate to hear, what anybody who has professional skills and abilities is for somebody to tell them, I've done my own research.
Mm.
I'm
trying to confirm now. I just want to ask questions about these certain laws that
I'm just saying, there's a lot that goes into understanding legal issues, and you've seen me on this hearing, so you've seen me. I'm not going to railroad anyone. If it is not correct, I'm gonna tell you it's not correct.
Yeah.
If it is something I need to explain, I'm going to explain it to you, because I don't want anybody leaving here thinking that they have been mistreated by the court or they don't understand what's going on. But when I tell you I've done my research, is what causes nightmares for anybody, judges, lawyers, doctors, anybody who has been trained in a certain area, and then they have somebody who said they went on the internet and they found some stuff. When I tell you, it drives us crazy, because it took me 4 years in law school, 4 years in college and 3 years in law school, and then practicing for years and years and years to get all this under my belt. And I still have a book. I have a computer database that encompasses a whole wall full of books and statutes and rules that I have to go to and I have to understand. Now, the reason I know this area of law so well is because I spent 4 years in magistrate court, and most of these cases usually come through magistrate court. So I've dealt with this, not only the 4 years I spent in magistrate court, but the 9 years I've spent on this court. And when I tell you, when somebody says, I've done my research, and then they start quoting and citing to federal regulations or federal statutes that don't apply to what we do, or they're citing to UCC when it's not what we're talking about, then the problem becomes how to make you understand and get you back on track.
Oh, that's correct. Okay. Now, I understand what you're saying. I definitely do. So basically, like the USC laws wouldn't apply in this situation.
This is a straight contract issue. Straight contract. The contract began when the company, the bank loaned you the money. The contract says they're gonna lend you the money. You're in exchange for that, you're gonna pay it back with interest. Your interest rate was 8.97%, and then there was some fees that the bank charged to make the loan. They're not even asking for the fees or the interest. They're just asking for the $5,000 principal. So they're willing to give up $725.80 plus whatever was owed since the time you failed to pay. And because of that, they just want $5,000, and then they want $266, which includes the filing fee and the service fee. Am I correct, Mr. Pippin?
That's correct, Your Honor. That's all.
So they're not even asking for interest. They're not even asking for the bank loan fees. They're not asking for any of that.
And no attorney fees either, Your Honor.
They're not, yeah, they could have asked for attorney's fees. They're not asking for that either. So A, I'm going to deny your counterclaim for $350,000. And B, unless you can tell me something different, they've established what they need to establish, that there's a contract present, a loan was paid, the loan was made at an interest rate of 8.9%, and there were fees due for the loan origination. The loan was not paid back, and really asking for the original principal of $5,000 plus court costs.
Okay. So also, I don't want to get upset. So also, does the truth and lending apply?
It's just, people
I'm just trying to
say,
understand. I want to know. I'm intrigued by it. I really am. Right. This whole thing got me into doing my research. I didn't care nothing about none of this until I found out that I was being sued or whatever.
I get that, but research without context. So there's a gajillion things on the internet, not all of them true and not all of them relative. And so just being able to Google something doesn't point you in the right direction of where you should actually follow for what's going on here. So you could get a ton of information from the internet. That's how you ended up with a RICO claim in your counterclaim. But does it apply, and is it appropriate for the court to grant or deny?
So I would like to know, does the Truth in Lending Act apply in this case?
Okay, how have they violated the Truth in Lending Act?
So I asked them, and they admitted that it does apply. And let me get my note.
But how have they violated it? I mean, the fact that it applies is one thing. If they violate it, that's another thing. How have they violated it? See, that's what I mean. You say things you hear or you read, but you don't know how they apply.
And this is why they have attorneys to take care of things like this, because they know the law.
So basically, that's where I got these laws from when I started doing my research within the Truth in Lending Act, when I brought up the 12 CFR and the USCs or whatever. So basically, that's why I was bringing up with me extending my credit. Is that not make me the creditor?
But you didn't, sir. You didn't extend your credit. You borrowed, which makes you a debtor. There's no credit for you to extend. The bank had the credit. The bank had the money. Credit means you start out with something. If you're a creditor, if you have credit, it means you start out with something. If you borrow $5,000, you're starting out with nothing and you're asking somebody to give you $5,000. Creditor means you got the 5. Borrower means I'm asking, debtor means I'm asking for the 5. So where's your credit, sir?
Okay, so 15 USC 1602.
No, sir, no.
That doesn't apply?
15 USC 1602 is the key terms for the Truth of Lending Act.
So I'm just
So you just
So
looked
the
up a word
contract-
stuff that doesn't apply.
So the contract is not the credit card.
It's a personal loan, sir. It's not a credit card. You went to a bank, you asked for a loan, they gave you a loan, they want their money back.
So are there any other genuine issues we to discuss?
No, sir, none that I'm aware of. I'm going to grant judgment in the amount of $5,000 plus $266 in court costs to the plaintiffs. I'll get you an order, Mr. Pippin, if you or your or the other attorneys will prepare that order, or if you've already sent one in, we'll sign it.
I'm sorry, I didn't mean to interrupt.
And then also the counterclaim has been denied in full.
Your Honor, thank you. I will make sure the court gets an order. I don't know if my colleague has or not. And I obviously cannot give opposing parties legal advice, but if a little bit of this effort, instead of future research, is spent reaching out to the firm, they'd be more than happy to work out some kind of payment arrangement and get this resolved so as to, have it beyond, in Mr. Whitney's past. So without giving advice, I think that would be a wise decision if it were me.
All righty. So at this time, the court has addressed each of the cases on the calendar. The court is adjourned. Mr. Whitney will go ahead and make sure you get a copy of the court's order, okay?
Okay.
All right. Thank you, sir.
Thank you for all your time today, Your Honor. I hope you have a good day. Good evening.
No problem.
Okay, I definitely can't say what I think somebody knows and doesn't know, but seeing him not really understand that it was a loan, he asked, was it a credit card? I'm not sure if he's just trying to play the game and just make it seem like he doesn't know so he doesn't have to pay back, but we could talk about it in the comments. I hope you enjoyed this video, and I'll see you around on the next one.